Hi, I'm Zach Rothenberg, litigation partner at Nelson Hardiman LLP in Los Angeles. I'm back with another installment of our video series on healthcare reimbursement. Today's topic is what to do when you receive an overpayment determination. First, what is an overpayment determination? They're frequently called recoupment demands or demands for recoupment. And sometimes they are a lengthy and detailed letter that spells out all the reasons why the insurance company is contending that they have paid you in error or more than they think they should have. More often than not, in my experience, it's just a vanilla spreadsheet with a list of claims without any explanation of what it is or why it was paid in error. The bottom line is it's the insurance company telling you that they've paid you by mistake or paid you more than they thought you deserve and they want their money back. Now here's the top 5 things you need to know if you get a recoupment demand. Number 1, the insurance company generally has only a 1-year statute of limitations or look-back period from the time they made the original payment to the time they make the demand for the recoupment. And this comes right out of the insurance code. Now, in my experience, the insurance company will frequently just give it a shot and send out a recoupment demand on claims that they know are more than a year old, just hoping that maybe the provider won't know their rights and will send in a check. Don't let that be you. You can push back. Number 2, if the overpayment was based on a mistake that the insurance company made, they probably cannot hold you responsible. Here's an example I see a lot. You call the insurance company to verify benefits, and the insurance company confirms that the patient has benefits under the policy, and they authorize the care. You do the work, you bill the claim, you get paid. And then sometime down the road, lo and behold, the insurance company writes you a letter and says, whoops, we made a mistake. Turns out the patient didn't have benefits, and we shouldn't have authorized the care. We want our money back. No. In that instance, it's the insurance company's mistake, it's the insurance company's problem, not yours. Number 3, there are significant restrictions in the ways that insurance companies can recoup from an out-of-network provider, even if it really was a legitimate overpayment. Now, I say out-of-network because chances are if the provider's contracted, the details of how and when the insurance company can recoup probably comes right out of the network agreement. But for an out-of-network provider, what's important to know is that the insurance company can't just automatically reduce other future reimbursements as a way of recouping money they believe was paid in error, so long as you timely dispute the recoupment. And also remember that different patients can have different plans, even if they're all administered by or under the umbrella of the same insurance company. If the insurance company tries to recoup payment for your treatment of patient A by reducing your reimbursement for the treatment of patient B, that can be a real issue if patient A and patient B are members of different health plans. So keep that in mind. Number 4, the insurance company generally has to provide you with clear reasons for the supposed overpayment and documented evidence to support those reasons. There are a number of sections in the California Code of Regulations and the Code of Federal Regulations that support this requirement. In my experience, providers generally only give a very brief description of why they think the payment was an overpayment, if anything at all. More often than not, like I said, it's just a list of claims with no discussion. But if you're not given detail and evidence, you have the right to demand specific information from the insurance company to support the overpayment claim. Plan agreements for each claim, policies that the insurance is relying on to claim that it's an overpayment, the administrative services agreement between the health plan and the insurance company, any documents from or correspondence with a third-party administrator like Multiplan or Viant, communications with the patient whose claims are at issue, and communications between you and the insurance company, for example, audio recordings of your verification of benefits calls. And if the overpayment is based on a medical necessity issue, you're entitled to clinical records and analysis that would support the insurance company's medical necessity conclusion. Now note this is helpful for 2 reasons. First, this is information you can use to oppose the recoupment, but perhaps more importantly, it sends a clear message that you're not going to get pushed around. If they are looking for low-hanging fruit, it's not going to be you. The bottom line with all of this is that insurance companies are taking great liberties with recoupment demands, looking for low-hanging fruit, the folks who decide not to put up a fight and just to send in a check. It's critical that you know your rights, you know where you have leverage, and you know when you can push back. Don't be the low-hanging fruit. Well, that's it for today. Thanks for listening.